Fellow Americans, a critical legal battle is unfolding, threatening to redefine the very landscape of our Second Amendment rights. The Fifth Circuit Court of Appeals has just delivered a stunning decision in the case of United States versus Peterson, a ruling with grave implications for every law-abiding firearm owner, particularly concerning suppressors and the National Firearms Act. This is not merely a legal technicality, it is a direct assault on established protections, dressed in the guise of administrative process. The urgency of this moment cannot be overstated. We are witnessing a dangerous erosion of foundational rights, as the very concept of shall issue permits is being twisted to justify broad federal taxation and registration schemes. At the heart of this legal quagmire is the Peterson case, which challenged the constitutionality of the National Firearms Act, specifically its application to suppressors. Mr. Peterson faced conviction for possessing an unregistered solvent trap, an item the government deemed a suppressor and therefore subject to the NFA's stringent requirements. His defense: the NFA's restrictions on suppressors violate the Second Amendment. Initially, a three-judge panel of the Fifth Circuit sided against Mr. Peterson, ruling that suppressors were not protected arms. However, in a significant shift, the Trump Department of Justice later conceded that suppressors are indeed arms protected by the Second Amendment, a position articulated in a brief to the Fifth Circuit. Crucially, the Department of Justice simultaneously argued that despite this protection, the NFA's restrictions do not constitute an outright ban and are thus permissible under current Supreme Court precedent. This shift prompted the original panel to withdraw its opinion. Yet, upon reconsideration, the three-judge panel reissued a new, equally alarming ruling. They concluded that even though suppressors may be protected arms, the NFA's restrictions remain constitutional. Their reasoning? They asserted that under the Supreme Court's Bruen decision, the NFA operates as a shall-issue permit scheme, which they deemed permissible. This interpretation is profoundly concerning. The Bruen decision, specifically Justice Kavanaugh's concurring opinion, discussed shall-issue, concealed carry weapon schemes, suggesting they might be permissible if based on objective criteria such as background checks and fingerprinting. However, the Fifth Circuit panel has dangerously extrapolated this concept, twisting the Bruen framework to legitimize the NFA's long-standing taxation and registration requirements for items like suppressors. Mr. Peterson immediately sought an en banc review from the full Fifth Circuit, arguing that the panel fundamentally mischaracterized the NFA. He contended that the NFA's taxation and registration system bears no resemblance to a shall-issue licensing regime. The Trump Department of Justice, in its response to the NCU-Banky petition, doubled down on the panel's reasoning, insisting that the NFA is indeed constitutional as a shall-issue permit scheme. They further attempted to downplay the ruling's broader implications, claiming it only applies to NFA restrictions on suppressors, and perhaps only to Mr. Peterson himself. This is a false comfort, a dangerous precedent in the making. The Fifth Circuit has now issued an order vacating the stay on the panel's decision, effectively allowing the three-judge panel's ruling to take effect. This action strongly indicates that the en banc review has been denied. The implications are stark. The Fifth Circuit now officially endorses the dangerous legal fiction that the NFA's confiscatory taxation and registration scheme can be equated with a shall-issue permit system. The ramifications of this decision for citizens are severe and multifaceted. If this interpretation holds, the financial and legal burdens associated with NFA-regulated items will remain in place and potentially expand. The NFA already imposes substantial fees and a convoluted registration process that can take months or even over a year to complete. Each NFA item, such as a suppressor, machine gun, or short-barreled rifle, requires payment of a $200 federal tax stamp and approval from the ATF. Failure to comply with these regulations carries catastrophic penalties. Possessing an unregistered NFA item, or a component deemed by the ATF to be an NFA item, can result in up to 10 years in federal prison, a fine of up to $10,000, and the permanent loss of all firearm rights. This is the legal trap into which Mr. Peterson fell, caught in a dragnet over an item initially found in his home safe, an item he claims was an unregistered solvent trap, not a suppressor. The government's ability to interpret common items as NFA-regulated components creates an ambiguous and perilous environment for law-abiding citizens. Furthermore, the shall-issue designation, as twisted by the Fifth Circuit, implies that while registration might be difficult, it is theoretically achievable. This subtly shifts the burden onto the individual to navigate an intentionally complex bureaucratic maze. Any misstep, any overlooked form, Any delay in processing could transform an otherwise legal object into contraband, exposing the owner to severe criminal liability. This system is designed to create a chilling effect, discouraging ownership through complexity and fear of accidental non-compliance, rather than outright prohibition. The NFA's shall issue permit scheme is, in reality, a labyrinth of bureaucratic hurdles and financial drains. It demands extensive paperwork, including ATF Form 4 or Form 1, fingerprint cards, passport-style photographs, and a chief law enforcement officer signature or trust registration. The average processing time can stretch from several months to well over a year. During this waiting period, the item remains legally inaccessible to the purchaser. Each of these steps represents not just time and effort, but also direct and indirect costs. The $200 tax stamp per item is a significant financial burden, especially for individuals seeking to own multiple NFA-regulated devices. The fees for fingerprinting and photographs add to the expense. Legal fees for setting up a compliant NFA gun trust can easily run into hundreds of dollars. The ATF's regulatory interpretations are also notoriously fluid and subject to change, as seen with their recent reclassification efforts regarding pistol braces and solvent traps. This means that an item legally acquired one day could be deemed an unregistered NFA item the next, through no fault of the owner, merely by regulatory fiat. This unpredictable environment places an immense, often invisible burden on citizens trying to remain compliant. The shall issue label is a smokescreen for a system designed to be financially draining, time-consuming, and administratively punitive, effectively restricting access to protected arms through prohibitive process rather than outright bans. The most dangerous aspect of the Fifth Circuit's decision is its broader implication: the potential erosion of Second Amendment rights by legitimizing complex regulatory schemes as shall issue permits. If the NFA's taxation and registration requirements for suppressors can be justified as a permissible shall issue system under Bruen, what other firearm accessories or even basic firearms could be subjected to similar schemes? This ruling opens the door for other states or the federal government to impose similar objective criteria, such as excessive fees, prolonged waiting periods, and mandatory registration on a wider array of protected arms. Imagine a future where semi-automatic rifles or even handguns are subjected to NFA-style taxation and registration, all under the guise of a shall-issue permit. This decision transforms a fundamental right into a privilege, contingent upon navigating a Byzantine bureaucratic process and paying a steep financial toll. It effectively redefines the line between a ban and a regulation. By accepting the premise that a highly restrictive, expensive, and time-consuming registration and taxation scheme can be equated with a simple shall-issue permit, the court has provided a dangerous blueprint for future infringements. This is a profound shift from the spirit of Bruen, which sought to protect the right to bear arms from arbitrary and subjective restrictions. This ruling injects subjectivity through administrative complexity, making compliance so onerous that it acts as a de facto ban for many. The Fifth Circuit's denial of an en banc review in the Peterson case is a significant setback, but it is not the end. Mr. Peterson now has the option to appeal to the Supreme Court. This case will likely join two other NFA-related cases concerning short-barreled rifle restrictions, which are also currently seeking Supreme Court review. The Supreme Court's decisions in those cases could provide crucial guidance, potentially influencing Mr. Peterson's path forward. This legal battle underscores a critical truth: our rights are never truly secure. They must be constantly defended against insidious legal interpretations and bureaucratic overreach. This is a call to vigilance, to remain informed, and to support the organizations and individuals who are fighting on the front lines to protect our fundamental Second Amendment rights. The future of firearms ownership and the very definition of a protected arm hangs in the balance. We must stand together, for this country was forged by vigilant citizens, and it will be preserved by those who stand ready to defend it.